Stay tuned for the next edition of Zoom Landlord-Tenant Talk Radio. The opening topic, breaking news. Landlords, your eviction notice is probably wrong. Hello, hello. Yes, another edition of Zoom Landlord-Tenant Talk Radio coming at you every Saturday at 3 p.m. If you were listening to the broadcast live, the name of the song was The Sound of Silence, performed by Simon and Garfunkel and released in 1964. Now, the inside story about that was that Simon wrote the song in 1963, shortly after the assassination of John F. Kennedy. The lyrics reflect the sense of alienation, disconnection, and struggle to communicate in a world that feels increasingly impersonal and troubled. Now, Simon said that he wrote the song while he was in the bathroom, where he would turn off the lights to create a sense of isolation and focus. The famous opening line, "Hello, darkness, my old friend," is a direct reference to this habit. Okay, I have an announcement. Next week, the show will air on time. However, there will be no question and answer period. It'll just be the opening topic, and that's because I'll be on some sort of a plane ride to Spain. And then I'll be on a boat, and I was told that I'm actually sitting in the back of the boat, so I don't have to row as hard as the people in the front of the boat. Okay, let's talk about the show format. The show format is that I always have an opening topic. And then if you are in the Zoom meeting room, I will answer your questions. Please electronically raise your hand. I do answer or ask the questions in those orders upon which you electronically raised your hand. If you're watching this on YouTube, thank you very much. I would ask if you could please hit that like button and subscribe to the channel. I'm proud to tell you that I just passed 6,000 subscribers, and that really does help me. Also, if you're in YouTube and you want to get your questions answered, just please leave it in the comments and I'll be sure to answer that for you. Okay, let's talk about the opening topic. And what is that? And that is breaking news. California landlords, your eviction notice is probably wrong. There was a court of appeals case called Eshagian versus Cepeda. And the background of that case was that the tenant, Cepeda, agreed to pay his landlord, Joseph Eshagian, $1,000 per month. Now, Mr. Cepeda stopped paying the rent for 8 months, and that was from April 1st of 2022 through November of 2022. That was 8 months, a total of $8,000, and eventually this kind landlord eventually had to serve a 3-day notice 8 months later for the $8,000. Well, the tenant answered the lawsuit, and in his answer, he denied that he owed that sum of money, and he also claimed that the premises were uninhabitable. By the way, every tenant in every eviction case for non-payment of rent claims that the premises are uninhabitable. Now, he did not contend that the notice that he was served with was defective, and he didn't contend that he couldn't understand the notice. Okay, so he never made any reference that the notice was bad, never made any reference that he could not understand the wording of the notice. Now, during the course of the lawsuit, Mr. Cepeda was served with discovery. That's a series of questions that any litigant in any lawsuit can serve the other party. And in this case, the landlord served him with discovery, a series of questions, because the landlord wanted to know, well, why do you say you don't owe $8,000? And also, when you're claiming things are uninhabitable, what's uninhabitable? And when did you tell me about that? Well, he was served with those discovery responses, and he didn't answer. So finally, the landlord, through his attorney, filed something called a motion to compel with the court, forcing the tenant to respond to those questions. Seems very fair. So a court hearing was held, and the court ordered him to respond. Well, Mr. Cepeda still didn't respond. So the attorney for the landlord brought forth another action, a motion for terminating sanctions. And that is, hey, he still didn't answer the lawsuit. I would like his answer stricken. And of course, the court was duty bound to do so. So they struck his answer, which means that the court could then issue a default for possession so that the landlord could have the tenant evicted from the properties. Now, the court at this time didn't order a judgment for the amount of money owed. It was just for possession. You would generally, in unlawful detainer law, get that after the tenant is evicted. Now, a writ of possession was delivered to the sheriff's office, and in fact, the tenant was locked out on June 8th, 2023, owing over 11 months worth of rent. But prior to the time that he was locked out, on May 19, 2023, the tenant attempted to set aside the judgment on the basis that that 3-day notice was defective. But of course, the court refused, stating that, hey, these deficiencies should have been raised prior to the issuance of the judgment for possession. And once we do the judgment for possession, it's finalized. Now, I don't want to confuse you with too much legal jargon, but the appellate department and the Court of Appeals both indicated that the judgment for possession could not be appealed because the judgment wasn't finalized, because they still hadn't dealt with the issue of the monetary judgment for the rent owed. But they did state that the case could proceed on the basis of something called a writ of mandate. It's kind of like another type of an appeal. And of course, then the court did hear it based on this, quote, writ of mandate. Now, in this decision, the court set out the requirements of what must be contained in a 3-day notice to pay rent or quit. Now, I believe that the court overstepped its jurisdiction by raising issues that were not even part of the appeal. But of course, that's what this Court of Appeals did. So I want to share my screen with you right now. And I want to show you what now the court is claiming needs to be in this notice. And there we go. So what needs to be in this notice, maybe I can make that even a little bigger for you guys. Maybe one more hit. Okay, so what needs to be in the notice, it must state, of course, the amount of rent that's currently owed, okay? Let me get rid of this. And it must state how rent is to be paid. That is, the address and phone number of the person who will be accepting the rent. And I might add that in this case, the landlord, Mr. Eshagian, stated that he would basically pick up the rent from the tenant's apartment. But of course, that's not a proper notice. You have to actually have an address and a phone number of a person who's willing to accept the rent. So where he can go to pay the rent, even if it's a bank account or even if it's a post office box. And also you have to state the times when rent will be received. It must also state that failure to pay rent will result in the landlord seeking possession. It could just not state pay or quit. Now, I haven't seen the tenant's 3-day notice, what was contained in that lawsuit, because that file is masked and it wasn't contained in the appellate record. However, I think that notice just said pay rent or quit. Well, the court went on to state that it must state that if you fail to pay within the 3-day period, the landlord will seek possession of your unit. So the Court of Appeals found that the notice was defective because it didn't have that exact language. I know in my website, I've always had that language in there. But then it took another step, a step that I don't believe that the court had to do, but that's what they did. And it stated that the tenant must be aware of when the notice will expire. It must be aware when the notice will expire. Now, again, this is new ground for the court because every notice says you've got 3 days to pay the rent. It doesn't state when the notice will expire. You don't have to have that exact language in it or what date, compute that for the tenant. But the court ruled that the notice was merely dated a certain date, and I'm just going to make up one, December 2nd of 2022, and it really wasn't served until December 7th of 2022. So the court reckoned that anybody looking at this would determine that the 3 days have already passed and therefore not attempt to pay the rent. Of course, in this case, the tenant never claimed that he was going to pay the rent. Okay. But court now states that we have to make sure that the tenant is aware when the notice will expire. So I have made some changes to my notice, which is on my website at evict123.com. Go into the free form section. So I have my notice here. Let's see if I can make this just a tad bigger so you guys can see that. And as you can tell here, it's fillable on this. So you always want to write in, for example, the name of the tenant. Then you want to write in the exact amount of rent due. Do not include any late charges or any other thing other than rent that's currently owed. You want to put in the period for what's rent is owed. So if the tenant owed June and July's rent, you would write in this spot here, June 1st to, and then you would do through July 31st if rent is payable on the 1st of each month. Then you're going to drop down and you put the address of the property, of course. But now I've kind of changed this up. So I don't want the tenant to think that the date on the notice is the date that the notice was served. So I've now changed my notice, which is online, and it states notice was prepared. Now, the day you serve the notice is not necessarily the day you prepare it. You could, for example, prepare it on a Saturday and serve it on a Monday, okay? So that's why I've changed this to date the notice was prepared, not served. Then I have here, as the court requires, who do you make the payment to? And that has to be where you're going to, who you make the check out, for example. So if it's under an LLC or a management company, you would write in XYZ Management Company. Dropping down, you have to have an individual's name, okay, as to who you pay the rent to, an address where to pay, and you can't use the tenant's address, okay? It has to be a physical address, a PO box, or you can actually have it paid to a bank. You'd have to write your account number, the name of the bank, a bank address, which is in 5 miles of the tenant's property. You also have to state the hours upon which the bank is open. And you do have to have a phone number. For unincorporated areas of LA County and the city of Los Angeles, you do have to have a bedroom count. And last but not least, and this is also new, I put into the notice the date the notice was served. So when you go to the property and you're going to either hand it to them or post it on the door, you're going to write the date that the notice was served. And I'm going to pretend that we did it today. So that date must be in there, even though this date here, the date the notice was prepared, could be something different, like July 10th. Okay? All right, so that's the story with regard to the new changes in the law. Make sure that you do go to my website, evict123.com, and get this latest edition, because I can just see people coming into court and stating that the notice was not done correctly. Now, if you have a case pending and you did use the notice that was on my website before, I believe my notice that was on the website before is sufficient. I don't think it did need any change because it did specifically state 3 days after you were served. And then we count, of course, business days, not Saturdays, Sundays, or judicial holidays. So I don't think you need to dismiss your lawsuits as long as you were using a notice such as mine as it was before, or a similar notice. However, going into the future to prevent any possible argument on your case, I would certainly recommend that you use my notice. And that, ladies and gentlemen, concludes the topic of the day. Breaking news: California landlords, your eviction notice is probably wrong. We're now going to open it up to questions and answers, and we know that this is for informational purposes only. It is not a substitute for getting legal advice. If you do want to talk to me and you are in the Zoom meeting, please electronically raise your hand, and I'll be happy to call on you in the order upon which you raised your hand. If you are on YouTube, once again, please hit that like button and subscribe to the channel. And if you have questions, put them in the comments and I will get to them, I promise. And this forum is for general questions only. If you do have a case with my office, God bless you. But we'd only talk about general questions of law. And last but not least, if you are talking to me, please leave your camera on because it makes more enjoyable for all of the audience and also for me as well. And with that, we're going to open it up to our first caller. Arlene, I'm going to ask you to unmute yourself.
Hi, Dennis. Thank you. That was really educational. I appreciate it. And I hope you have a wonderful vacation. LARSO, I have a tenant that I paid the interest on their security deposit in December. They're moving out the end of this month. Do I owe them a prorated amount for security, for interest for the 7 months that they're there?
No, it says that you have to pay it annually, and since it's a proration, you don't have to prorate it. But that's a good question.
Okay, and then one last other question. So when the new tenant moves in and I give them their first month's rent, can I add the $444 skip fee to that, or do I have to wait an extra month and serve it as a separate notice with 30-day notice?
It would have to be a separate notice. It's not upon entry.
Okay, thank you.
Thank you. We are moving along to the letter D. How are you?
Good, Dennis. Question, the property in question is 4-unit in Glendale. Yesterday, demolition of a next door duplex began. A tenant of mine complained he saw some insulation amongst the demolished property left behind. He said it was dangerous. He even sent me like a snippet off the internet of how insulation exposure could be bad for you. Called the police, city, and fire, and they told him to contact, I believe they told me to contact the inspection office. Today he texted me saying that he might have to get a hotel room and deduct from next month's rent because the demolition is, he said, unbearable for the residents. I haven't heard anything from any other tenant. Additionally, I'm staying at that complex because there's just an empty unit there. How would you recommend I respond to him and handle that situation?
I would recommend that you tell him to immediately get a hotel room. I would tell him to at least get the Four Seasons or the Ritz-Carlton. I would tell him
Okay.
that he should be scheduling a massage every day at 3 p.m., except for Saturdays when he should be
Okay.
watching this show. Because if he
Right.
was watching this show, then he would know that he can get that hotel room, but it's certainly on his dime. The only
Okay.
person who he shouldn't call based on the situation that's occurring next door is you. You have nothing to do with this. You have no responsibility in this situation. If he
Okay.
thinks that the next door neighbor is going outside the law with regard to their construction, well, then he needs to call Glendale Building and Safety, call the police, call the fire department, call anybody he likes, but don't call you.
Fair enough. Thank you so much, Dennis. I appreciate it.
You're very welcome. Okay, moving along to Josh Hatton. I don't think I've talked to you before.
Hi, I'm new. I'm actually on my husband's account. Nice to meet you, Dennis. So I have a tenant who lives in a single family home in Los Angeles, and he's been there for about 10 years, and he also has some roommates that are not supposed to be there. The house is in deep need of a remodel, and we already have a permit to do that. And he pays about $3,000 in rent right now. So I want to understand how I can legally evict him, and what it will cost me. And are there any issues I have to deal with the moratorium with the fires?
Okay, well, first of all, the city of Los Angeles for properties that are subject to just cause ordinance, such as your single family home, which I presume only has one house on the lot.
It does right now only have one house on the lot, but when we do the remodel, we're going to be adding two ADUs underneath it.
Okay, well, right now, the city of Los Angeles has permanently banned evicting a tenant based on substantial remodel. So there's really little that you can do to ask that tenant to move. Nothing prevents you from raising rent because it is a single family home, with the exception of that emergency order by the governor of California based on the fires. You can right now raise the rent 10%, but you can't ask these tenants to move because you want to remodel the premises. It has nothing to do with relocation. It's just it's not proper to do so.
But what if I want to remodel downstairs and it's going to disrupt his kind of enjoyment of living because I want to make it into a triplex? Do I have a right to do that? Or not a triplex, but a house with two ADUs?
Well, first of all, what's underneath his house right now?
Right now, there are two apartments that were not permitted that we got rid of the tenants, and now we have permits to do it correctly.
So he wasn't leased that space, correct?
Did not lease that space.
So you have every right in the world to start your construction as long as you're working during normal construction hours, which are usually, 8 to 5, Monday through Friday, and then they allow some time on Saturday. If you're working within the laws of, building and safety, then you're fine. You
So I
might
can
want
only,
to
so I
send
can,
him you might want to send him a courtesy note.
okay.
But you might want to also try this, saying, listen, this is what's going to happen. It's going to be inconvenient for you. And also, once this is done, we're going to need to do a substantial rent increase on yours. So it might just be more worth your while to vacate. And if you do, then I'm willing to give you some relocation, and I'll just say something off the top of my head, $5,000. So it's kind of like the carrot and the stick routine where you're going to tell them, hey, it's not going to be pleasant to live here. Once the work is done, you're going to get a substantial rent increase. Costs, quite frankly, you can. And that's once the moratorium is over in October. And you're going to want to raise the rent because once you get your certificate of occupancy for those other two units, then his unit will be actually, they'll all be under rent control because it's just one structure. So I would try that carrot and stick approach.
But you just said I can only raise the rent 10%. If I wait till October, can I raise it more?
Yeah, the moratorium is going to be over as of the end of October. So then on November 1, unless our wonderful governor extends it again, the state of emergency would be declared over. November 1, you could raise the rent to whatever level you like.
With no penalty, I can raise it to whatever I want.
Whatever you want. The only penalty is if the tenant decides to move because he doesn't want to pay it, you'd have to pay him relocation. But since at this moment in time it's just a single family residence, then the relocation would only be 1 month's rent.
Got it. Okay, I have another really quick question. I have some very tiny apartments. They're singles. Am I allowed to limit how many people live in those?
You can, but it would have to be a minimum of 2. You can't
Okay.
just limit it to one person.
Okay, so even if it's a tiny little single one room with a little tiny kitchen, I can't limit it to one person, correct?
If you do, you will be sued. And do you know why you'll be sued?
Yes, because it's discrimination against family or something.
That is correct. So it means that a child would never be able to live in your unit.
Got it. And then if I'm paying utilities, am I allowed to ask for more utilities if there's two people versus one or no?
I don't have a problem with that, but I would advertise that.
Got it. So if it's more than one person, the utilities would be higher.
Yes, because quite frankly, you're paying for the utilities. So why shouldn't you pass that expense over if there's now going to be 2 people taking showers and using different electrical instruments?
Perfect. Thank you so much. I appreciate it.
My pleasure. Like seeing the new people here. We're now moving on to Glenn's iPhone. How are you?
Hi, Dennis. Good afternoon. I have a single family residence in LA County. The tenants recently moved out at the end of their lease, and they had two service German Shepherds that created a lot of damage. I did a lot of the repairs myself, and I'm curious if I'm legally allowed to charge for my labor and what a reasonable charge would be per hour.
Number one, you are allowed to charge for your labor. You have to keep track of your hours. What a reasonable rate is, I don't know. If you flip hamburgers now in California, you're entitled to $20. So I think your expertise in terms of cleaning up is worth at least $35, but that's just on the top of my head. So yes, you can charge. Yes, you can charge an hourly rate on that. And by the way, in case you don't know, I'm giving a speech on security deposits. It'll be online, and it's at the website for the AOA, Apartment Owners Association. Their website is aoausa.com. I'll be giving that this Friday. I believe the time is noon, but check their website, AOA USA, this Friday, the 18th, I believe. Yes.
Okay, I'll
Thank
check
you.
that out.
All right, moving along to a regular. Sam, how are you?
Hi, Dennis. How are you?
I'm good, thank you.
Good. Question: City of Huntington Park. So, if a you receive a trustee's deed for a single family residence and that was foreclosed upon. How many days notice must the new receiver of that trustee's deed at the foreclosure sale? 10 days to record, apparently. What is
Now,
the time frame to give notice to the occupants or persons that were foreclosed upon that they need to move? And then what is the procedure for, I guess, an after trustee sale eviction?
this is a single family home,
Yeah, single family.
and is the person in possession the previous owner or tenant?
Yes.
Okay,
Previous owner. Yeah.
okay, so once you record the deed, it's a 3-day notice to quit. That's a
Just a
case
3
that
no,
we,
not a 90-day, not 90 days.
no, it's a 3-day notice to quit served on the previous owner or someone who's like a relative of the previous owner who's not a tenant.
Okay. Okay. I thought it was for some reason 90 days. Okay.
Oh, no.
Okay. Thank you.
Okay, moving along to Harold Rhodes. How are you?
Right. Dennis.
Hello.
Oh, can you hear me?
I can, but your
All
camera's
right.
a little low.
Oh, okay. Is it better like this?
Oh, yes. Did
Okay,
you just
good.
gain some height there?
I guess I just moved my laptop up a little bit. So
Okay.
anyways, congratulations on your vacation. And I was curious with Costa Hawkins, if I want to evict the tenant and give the notice, what is the procedure and what would that letter sound like since it's like since it's like a month to month?
Well, Costa Hawkins doesn't talk about evicting tenants. It talks about being able to set rent limits. It doesn't
Oh,
talk
just over
about
that.
evicting tenants.
Okay, so what is the procedure? I just give them the 60-day notice and that I'm taking back the place, possession, and then
Again, that has nothing to do with Costa Hawkins. Again, Costa Hawkins deals with increasing the rent. For example,
right.
if it's a single family home with only one house on the lot. Costa
Yeah.
Hawkins says you can set the rental amount to whatever you like, but it doesn't talk about that, how to evict that tenant. That's not part of the Costa Hawkins Rental Housing Act.
Okay, so then what would it be just to do what I said other than Costa Hawkins as far as I want to just take back my place, owner something, move in, even though I live here?
Okay, well, if you wanted to take back your place, again, you're in the city of Los Angeles, correct?
Yeah.
I think we've discussed this before. You're just going to serve on your tenant a 60-day notice. You do not need a reason.
Okay, I don't need to register with the city about that or just give them the notice.
You do need to, under the just cause ordinance, since you do have a tenant to, actually, no, I take that back. Since you live in the unit 2, you don't have to even register it under the just cause ordinance. They don't consider that part of their statute.
And real quick, just as far as the letter, I mean, does it have to be a formal type of letter or just like I'm not renewing the lease? Here's your 60 days. I'm taking my place back.
Just do a 60-day notice. That form is on my website.
Oh, cool, man. Enjoy your vacation, bro.
Thank you very much. Okay, Tony L., how are you? Mr. Tony L., there you go.
I had to unmute myself. Sorry. Okay, so thank you so much for this, Mr. Block. Now, here's the deal. I'm moving back into my house. I'm in an apartment right now, but I'm moving back into my house. And there's a tenant that's been there about 2.5 years and she doesn't want to leave. And I went to the LAHD and I've been in there maybe 3-4 times a week, trying to make sure I do everything they said just right, paperwork just right, on time, etc. Because I'm scared to pieces about messing this up. So I've gotten to the point where I did the tenant relocation letter for Miss Lim, who is my manager or whatever they called her. Okay. One, I did a 60-day letter. And actually, I looked on your website and pulled the verbiage off of that. And I put it on here and it's beautifully written, except I have on here, as required by California law.
Ma'am, we can't be reading notices because
Oh,
this is a show.
takes too long.
You might want to
Okay.
call the office. I can tell you that on my notice that's on my website is a generalized 60-day notice, and you have to have specific language to be in compliance with the Los Angeles Housing Department when you're moving into your own unit.
Right,
The declaration has to be served with that notice.
right.
And also, of course, the
And they stamped
relocation,
it
which
here.
assuming it's only a 1 month's rent,
Right.
assuming it's a single family home would only be 1 month's rent, but I
And
can't
they've
really go
gone
into
through it.
that.
And they've gone all through it and stamped it. Okay, now here's my question to you. For some reason, when I typed up the notice, the relocation letter, this woman pays her rent on the 20th every month. But for some reason, I put on here that credit in lieu of a final rent payment due August 1. I don't know why I put August 1 when she always pays on the 20th. If I was going to do that at all, that should have been the 20th of July, but I didn't. I just had the first on my mind.
I'm hearing what you're saying. We're getting too
So-
much into the.
So can I?
I would reserve another notice, and there's also certain language that has to be in a 60-day notice. And I'm going to kind of bet that for when you're doing an owner move-in, that language is not in the notice. So, but again, what you're saying is a mistake in that notice in terms of what your due date was and when the relocation in the form of in exchange for the rent owed is a wrong date. So I would redo it. But anyway, thank you very much. You might want to call my office. Lily's iPhone, how are you?
Hold on, huh? Hold on.
I'm holding. What should I hold on to?
Oh, it's not. Oh, okay. I thought it was a mute. Was that mute? Okay, good. Thank you.
Lily,
thank
we
you.
hear you. Go ahead, please.
Okay, finally I talked to you, and you will have a good vacation next week. Okay, Dennis.
Thank you.
And I'm sorry, my camera was not on. Okay, I have a quick question. I hope it's a quick question. Okay, I help my friend to manage 4 units in Montebello. I'm so sorry, my camera is not on, huh? Okay, anyway, I just helped her to evict a tenant. The tenant was a hoarder and she had so much stuff, was smelling, everything. Then she said the owner had a mow or whatever. Anyway, finally we got her evicted. But now, and she did a renovation. I tried to have her get a few contract to give her court, but she chose the lowest price one. But I just can't believe it.
Lily,
Yes,
I
yes.
love you, but you've got to ask me a question.
Okay, the
Okay,
question
you're giving me
is,
background and tenants out. I heard all this.
okay,
What is your question that the old
my
man can
question
answer for you?
is right now after renovation still has bad smell, still has all those animals, whatever the smell. I told her,
Okay, I get it. What's your question with
my
regard to?
question is, do you think that she needs to get somebody to redo it for the next new tenant?
Well, obviously, if the premises are unacceptable and have serious odor problem, you're only going to get complaints from the next person coming in. So definitely, I would do that. Anyway, thank you very much. You guys want to keep your questions somewhat succinct so that we can get to everybody. And now we're going to get to Janice. How are you?
Good. How are you, Dennis? I'm so happy that you get to go on vacation, but we'll miss you.
Well,
Um,
I get dragged. You know, they use the excuse this time that my son was turning 40, so we're taking everybody, all three kids,
oh,
the wife, the grandchildren, and even the girlfriend of my other son. So it's going to be a big party.
oh, that sounds great. On the issue you raised earlier on payment of late rent, that can't go to a company like Door Loop, which I use to get the tenants to pay the rent by my billing them on Door Loop. Would have to go to a bank since I'm in New York and the house is in California.
Door loop, and I'm not familiar with that one, but it's any agent you can say pay this agent just like it would be a management company. So I don't have a problem with that.
Okay, great. Thank you.
Okay, good question. And succinct, I might add. Scott's iPhone, how are you? I'm going to ask you to unmute yourself. Scott's iPhone. Okay, I think we're lost in action. We are moving on to VNC iPad. How are you? Please unmute yourself. Having a little problems here today. Anybody want to unmute themselves? VNC iPad? Last chance. Okay, we are moving on to, this is Devashi's, something like that. I'm going to ask you to unmute yourself.
Hey,
There you
Dennis.
go.
I have a quadplex in Valley Village, and I have one tenant who is on the lease, but her boyfriend's not on there, but I believe he's living there too. And so I recently inquired about it, and she said she had plans to add him to the lease soon, but I've gotten complaints from the other tenant that they argue a lot and they're just creating more, I guess, disturbance. So I don't want to add him on the lease, but do I have to, or can I refuse?
Right now, they haven't asked you permission and he's already living there. So I would immediately serve them with a 3-day notice to perform or quit.
Okay.
Giving
3-day
Go ahead.
notice, and then so I can say that they violated the lease.
Well, absolutely, because
Okay.
the rental agreement states who can
Yep.
live there.
Correct.
And right now, let me finish. They have a stranger living there that you've never approved of, never had a chance to give them an application. Plus, you're also getting complaints from the neighbors that there's now excessive noise and fighting. So I would definitely serve a notice to perform or quit, giving her 3 days to get rid of him. At the end of the 3rd day, if he's still there, you have the right to evict everyone from the unit.
Gotcha. Okay. Well, that answers my question. Thank you so much.
And thank you. We are going to move on to Janet Berry. How are you?
Hi, Janice. Thank you for being here for all the questions. So I gave a tenant 30-day notice of a 4% rent increase, about a month ago. It's the City of LA, an apartment building, and he's paying the rent, but not the increased amount. And it's becoming, I think he's, just a control
When did the rent increase become effective?
for July 1st.
I think as of July 1st, the city had a 3%. So then you're not paying for utilities, are you?
No, but I issued the increase June 1st or May to start on July 1st.
Yes,
So,
but as of July 1st, the rent increase was knocked down to 3%. So I think your notice is defective. I would reserve another notice and make it, right now, based on the date, I would make it effective as of September 1, and it's only 3%. You might want to check with the Los Angeles Housing Department, but that's my understanding that as of July 1, that the rent increase was 4%. So you're increasing it, I was 3%, excuse me, but you're increasing it as of July 1 as to 4%. So I think you're out of luck.
okay, got it. Thank you.
And thank you. Good question. And moving on to Tara Lewis, I'm going to ask you to unmute yourself.
Hi, Dennis. Yes, I had an apartment building. It's a 5-unit apartment building. RSO I purchased in 2014. I currently still have three of the 5 original tenants, with one tenant paying right around $1,000. My thoughts are, well, first of all, those 3 tenants, especially the one paying 1,000, is never going to move out. And my thought was, and because it's a 5-unit building, my thought was to go ahead and try to market the building for the best price I can get for it now, purchase a smaller building that doesn't have private trash pickup, which would be a 4-unit or less, and the replacement building would be with tenants that are much closer to the fair market value. So it's really a business question. Does that sound like a better plan, or just try to hang on to the ones and hope that the tenants, one of those 3, someday in the next 20 years might move out? Because
What city, please?
North Hollywood, Studio City.
Okay, so number one, it's not necessarily a legal question, but when you purchase the new property, you're probably going to get a loan, so the loan's going to be way higher. That's probably going to eat into any profit that you would otherwise be seeing. So you might want to incentivize that tenant to move by offering him a lot of money. And that in the long run might be worth it to you. You're saying his rent is $1,000. If you fixed up the unit, what could you get?
Double that.
So you're going to get an extra $1,000 a month. So that brings the price of the building up $170,000 as a general rule for $1,000 a month. So you could offer him a lot of money to get out. And even if you offered him $30,000 in 30 months, you've recouped that from the next tenant. So you might want to try that approach. But again, this would probably be something you should ask of your accountant.
I did do that. She was saying it's 6 and 1, half a dozen was her answer to that. Because I already have appreciation built into that property for the last 11 years.
Correct. But again, you're going to be paying increased interest unless you're just going to cash out.
No, I mean, it'd be a cash out and then add additional cash to get the better building.
Yeah, well, then that might make sense if you can get the right price for your building now. But again, I would check with your CPA. And with that, I'm going to move on again to VNC iPad. Let's see if you can unmute yourself now.
Okay, did it work?
Now it did.
Okay. I'm not even going to work with the camera. So, okay. So I have a tenant who's moving and asked if she can transfer the lease to an additional occupant and also her 14-year-old son. They're not on the lease. And we've only accepted rent from her. What do I do?
What city?
Highland Park, but it's non-RSO.
Okay. So your Highland Park would be under probably statewide rent control.
Yes.
And if you're saying you have your tenant and they want to replace themselves with another person and that person's child, correct?
No, it's her child, but she's leaving behind her child.
With who?
Her ex-boyfriend.
She's just giving up parenthood right like that?
Well, her mom left her also. Her mom was our original tenant, and she left her when she was 18 and moved to Mexico. And we've had her, the daughter has been our tenant for a number of years.
Okay. You don't have to allow for that situation. You tell her that if she moves out, that she's got to take this other occupant who you've never approved of and never taken any rent with her. If she does move out, that would be grounds for eviction or grounds to raise the rent on the remaining party.
My concern is that she keeps telling me I'm moving out, and yeah, I know she has moved out, but she has not given me like a 30-day notice or anything like that.
Does the rent checks keep coming from her?
It's out of it's Zelle payments. It's still from her.
So she's not there, but she moved in with her child, correct, originally?
No, she had the child there.
Okay, and the child's still there. She's not there.
She's not there.
And you don't have a signed rental agreement from this person?
No.
Okay, I still think that if she's not there and you can establish that, I think you have grounds for eviction. This is somewhat of an interesting issue that you should call the office on, but I think we might be able to do something.
Thank you.
Okay, moving along to Denny. How are you? Hello, Denny. Can I ask you to unmute yourself? There you go.
Hi, how are you?
I am fine, thank you. You're
Yeah,
an old-time client,
yeah, 25 plus years.
25. You don't
Yeah.
look a day over 30.
Oh my goodness. Thank you. Thank you so much for answering questions. On your breaking news, I have a two-part question. I know the courts, it was based on a 3-day notice, no fault or at fault eviction. Does this apply to no fault eviction?
No, I don't think it applies. It only applies to evictions where you're giving the tenant an opportunity to correct the breach. And if he doesn't, then you're going to go for possession. So that would apply, in my mind, to not only to non-payment of rent cases, but also to notices to perform or quit. And I've changed that notice on my website as well.
Okay. Then the other question is on a no fault eviction where you've already issued a 90-day notice based on major renovation and construction. This is for property in Long Beach. Would that affect this? Do you have to
Not at all. Not at all. Wouldn't apply. It would only apply to a notice to pay rent or quit or to a notice to perform or quit.
Okay. Thank you so much. Enjoy your vacation.
Thank you, sir. But I will be doing the show.
Okay, yes. Okay, good.
I will be doing the show next week,
All right,
but
thank you.
it'll be taped for a
Oh,
change.
okay, good.
Okay, we're moving on to Susan. How are you?
Hi, Dennis. I've used you several times in the past. My question is in regarding an eviction we just finished. The tenant never went to court, so the sheriff will be removing them. My thing is, I've noticed that you've finally added to your new version of the lease about personal property that when the tenant vacates, that it can be disposed of in any manner the landlord chooses. I've always had that in there since the first time one of your lawyers evicted one of my tenants because they told me that that would be a great thing to add in a lease. And I had it in the lease of this person that we evicted. I'm wondering when the sheriff comes and I have to give him a notice of right to reclaim abandoned property, because I had that clause in the lease about when they vacate, that basically the owner can do what they want with the items left behind. Am I held to the same legal responsibility of if there's, a broken down bed, a couch, a this, that
Okay, let me stop you here. If the sheriff does the eviction, then there's no need to serve on the tenant the notice of a belief of abandonment for the personal property. If the sheriff didn't do the eviction, then technically you would be bound to serve that notice, which is on my website. However, I believe that if the tenant signed an agreement which states that once you vacate, anything left behind is deemed abandoned and can be disposed of immediately, I think you have the right to do so.
So when the sheriff comes to do the lockout, whatever he grabs is it. I basically can be nice and give him his stuff.
I would certainly be nice because I'm sure you
Right.
don't want his treasures, but legally speaking, I don't think you have to.
Gosh, you enjoy your vacation, sir. You made me very happy. I was stressed about all this.
And thank you. Terry Munson, how are you?
Hi, I'm doing really well, Dennis. Happy vacationing. I just have a quick question. Are you familiar with SB 436? If I read the paragraph correctly, it has something to do with Sacramento's trying to change a 3-day notice into a 14-day period.
I'm reading it right now. It says the bill would extend the notice period from 3 days to 14 days. These politicians can't think of enough things to try to throw our industry, into the ocean. It's just one boondoggle after another. I don't usually comment on laws before they are laws, but I'm reading right now. It says it's related to evictions protection. Tenants don't need eviction protection. Tenants have all the protection in the world. The people who need protection are landlords. There should be anti-landlord harassment that the cities of Los Angeles and other ones should institute that, because the landlords are the ones that are harassed. But right now, this is not the law.
Okay. So wait till it becomes a law and then we fight it, or?
Well, I'm sure the apartment associations all send in their letters on this. You might want to write a letter to your assemblyman and your state senator that this would be crazy to extend this out another 11 days, so the tenants can sit there and not pay rent for another 11 days. This would just be terrible.
All right. Thank you, Dennis.
And thank you. Well, I want to thank everybody for joining our Zoom Landlord Tenant Talk Radio. Remember, next week, there will be no Zoom meeting, but there will be an opening topic that will be premiered next Saturday at 3 p.m. And the following Saturday, we're going to open it up again to the Zoom meeting and to YouTube with questions. But that time, I'll be doing it from my stateroom on the rowboat, which I think is called the Seven Seas Cruise Lines. And with that, everybody, you have a great, happy weekend.